Welcome, welcome, welcome to the Law, Your Money, and You. I'm Roberta Sapphire, an attorney in Sharon.
And I'm Camille Barron, a healthcare advisor and financial organizer, also in Sharon, Massachusetts, New England,
USA.
United States, and people can see us all
Anywhere
over
in
the
the
world.
world.
Anywhere in the world. by
Someday
going
in
to
Mars, too, and on other planets.
That's right, that's right.
But anyway, and they'll probably have those issues, too, that we're going to talk about today. We are so lucky to have with us our chairperson, chair of our advisory board, Attorney Emily Smith Lee. Welcome, welcome, welcome. We have new subjects today, which might take more than just this time. It'll probably do another session too, but you're always on anyway because you're such an integral part of our organization. But welcome. Why don't we talk right now about what we're going to talk about?
Sure.
Does that make sense?
So we've seen a lot of changes in the employment law landscape, and one of them is changes to the laws related to non-compete agreements, which are really actually pretty substantial. There have been a couple of other changes in Massachusetts rolling out around this time, changes in family leave available for employees with illnesses.
Question, is that just Massachusetts or is it all over? Are we following other states or federal or what are we doing?
So
on that?
right now, all the changes I'm talking about are Massachusetts. Other states may have rolled out similar things. There's a federal family leave law that's been around for a long, long time. The Massachusetts state one is new. The other change is in the state law around equal pay for equal work. Same thing, there's a federal counterpart to it. But there have been some changes that kind of broaden the definition and in some ways broaden the protections.
And let's just stop there for a moment. Generally speaking, not necessarily about employment law, when there is a federal law and then the states make the law, is the state's role to make the federal law more liberal, or can they just modify any way, shape, or form from what the federal says?
So it does kind of depend on the subject matter. If you're talking about things like employment, if you're talking about that kind of thing, the federal law sets the floor. The states can give employees more protection. So the federal law says you've got to pay people at least whatever it is now, eight something an hour. Massachusetts has always been above that, and we get to do that, but we can't just decide you can only get paid $5
Okay.
an hour. Does that make sense?
Yes, thank you.
Sure.
So the first topic is
Non-compete
non-compete agreement. So that
agreements.
means if an employee leaves a company they're working for, they typically in a non-compete, you have to agree that you cannot be in a business that competes with the company's business
Yep.
for a period of time. Okay.
Broadly speaking, yes. And in the broadest possible sense, before this new law was passed, and to some extent after, you can only enforce that kind of agreement if it's necessary to protect either the employer's proprietary information or their goodwill. You can't and never could really bind somebody to a non-compete just because you didn't want them to compete.
What do you mean by proprietary information for our viewers?
Commonly also called trade secrets, confidential business information. It typically involves things that the company keeps secret. So just because you figured out something very sophisticated as an engineer doesn't mean it's necessarily a trade secret. If another engineer who's as smart as you could figure it out. But if you've got a process, a system that's been put together within the company, sometimes people protect customer lists in the sales environment, that kind of thing.
Okay, so what you just described has been the way it's been up until this change. So what's changed?
So all of that is still the same. What's new is, and people may be watching this who signed a non-compete agreement 2 years ago, they're still under the old rules. Anybody who's signed one or is asked to sign one after October 1st of 2018 is under these new rules. So number one, they have to give you 10 days to think about it before you sign it. What used to happen is you start a job, you go in, you give them your, you fill out your tax form, you sign 1,700 pieces of paper, the drug policy, employee handbook, and at the bottom of the stack is a non-compete. And it's your first day of work. And you're looking at it and you really don't have a lot of choice. So they can't do that anymore. They've got to give you advance notice. They've got to advise you that you can talk to an attorney before signing it. They have to provide consideration. This has always been kind of true, but it's much more explicit. If they're asking you to sign an agreement to start a new job, that's okay. If they're putting one in front of you and you've already been working for them, they have to give you something of value. You know, they've got to pay you a bonus, give you a raise, do something. And the two most significant changes is there are whole categories of employees who no longer can be subject to non-competes.
Really?
So if you're not exempt from overtime, if you're an hourly worker, if you're a mid to low level employee, just hard no.
Really?
No more
Okay.
non-competes after October 1st.
No more non-competes.
Which
That's
it-
interesting. That's interesting. So you could have somebody who works 40 hours a week, but they're not a supervisor, they're not salaried, they're hourly, and yet you cannot make them sign a non-compete.
you could make them sign it,
Oh, it's not
but the statute
enforceable.
says that it doesn't.
Oh,
They
that's
can't be enforced.
interesting.
I mean, and this was to address, and we've talked about this on other shows, right? The
Yeah.
sort of the famous story of the Subway sandwich worker, you know,
Oh,
kid
yeah.
making sandwiches who was subject to a non-compete. That's unless they want to put him on a salary and make him a manager and make him exempt from overtime.
Yeah.
That's a no-go any longer. Which kind of makes sense because he's
does.
really not going to jeopardize his employer's trade secrets or goodwill by going to work at D'Angelo's.
Yeah. Okay.
The other huge change is something that's called garden leave. If you are
Garden?
garden, as in plants,
Oh, garden.
herbs,
Yeah.
it's borrowed from the British. If you're laid off from your job and you've got, say, a 12-month non-compete, they've got to pay you half of your salary for that 12 months if they want you to stay out of work.
Oh, interesting.
So even if you've signed a non-compete at the moment you leave your company, they've got a good financial reason to let you out of it if they don't want to pay you for 12 months.
Okay. And that's only if the employee leaves involuntarily. In other words, if the company takes action and they get laid, the employee gets laid off.
Yeah, what if he leaves voluntarily?
That's a good question.
I would think it's the same. Why does he have to go in the same field? Why can't he? Well, it has to be what the non-compete is too.
So it depends on what the
Yeah.
non-compete says you're supposed to do, right?
Right.
Some of them just say don't compete with us. Some of them say if you're in, you know, widget making industry, don't work in the widget making industry. So I think your question, Roberta, is why would you have to pay people? Why can't they just go get a different job for a year?
Yeah,
I think the problem, a lot of what's led to this legislation and what's led to lawsuits over non-competes over the years is that's harder than it sounds. It's harder than it sounds, particularly the higher up you get in a profession, because you know the more experience you get in something, the more specialized your skill set becomes,
Right.
and that's the industry that you know, and that's the world that you know. And then you also have to remember that if you went and flipped burgers for a year, for the rest of your career, you've got to explain that gap in your resume when you go back into your chosen field. So it
Yeah, it's
kind of
interesting.
multiplies over time.
What are some of the practical implications of this in terms of employees who sign one of these? What defines a competing employer or competing employment?
Good question.
It's a great question, and this is one of the ambiguities under the old law that's still going to plague us under the new law. So first, it depends on what the words on the page say, right? They may be very specific. They may say, you know, if you're a fitness club, for example, you agree not to work for any other, you know, membership-based fitness organization within X number of miles. That's pretty clear. What continues to be subject to lawyers and judges and everything else that I do all day is is that still reasonable to protect the company's interests? So is 15 miles reasonable? It depends how far people drive to go to a fitness club. You know, if most people won't drive more than 5 miles to change fitness clubs, 15 miles might be a lot.
Yeah.
If you're a salesperson and you call on people throughout New England might be a reasonable limitation.
Yeah.
And there are some that are global, and it's okay because the people's work for the company is global in nature. So there will still be work for me.
Attorney. I wonder, do attorneys have non-compete? I know.
No.
No.
Attorneys and
because-
doctors cannot be subject to non-competes.
Oh, really?
One might argue it's because there's attorneys who make the laws, but it's really, the idea is that patients and clients need to be able to choose.
Okay.
Yeah.
Interesting. So if you worked for a very large, maybe a national company with branches all over the country, and you specialized in employment law, would that preclude you from going off on your own and establishing your own law firm, specializing in employment law? Yes?
No.
No.
Well, no,
Oh,
because
you're
attorneys,
you're attorney.
because we're special. But let's pretend it's a non-attorney job.
Yeah.
But because this comes up all the time with people wanting to start their own businesses, you have to look at that the same way you would look at taking another job
Yeah.
as to whether it's competitive.
What about a patent law attorney?
Can they? Well, they're still not
They-
subject to
Really?
non-competes here.
Isn't
Yeah.
that interesting?
Yeah.
That's interesting. Okay, that's very interesting. So there's changes in there. So they're trying to protect the worker, like the company that has two or three businesses, and they have so and so working 20 hours for this business and 20 hours for that business, but yet it's all under the same roof. So they're treated as one employee. You have to give them overtime.
So that depends. You know, if you've got two related businesses, let's say you've got a painting company and you've got a couple of different entities, but they're all doing the same work, then that's one employee, all those hours. If they're really two different jobs, if you've got a painting company and you've got a rubbish removal service, I think that employee is two employees
Oh, you think that's two
for
employees?
purposes of.
There's a fine. I would think there's a fine line, depending upon which way you want to see it. But if the guy paints at this facility, but at that facility they don't need him for painting, they need him for that. They need him for emptying the rubbish. So then the facility he paints for, they say, hey, can you just take the rubbish out for this day and that day? And then there's
So that's a whole other.
yeah.
That's a whole other conversation about these two companies. You know, for a lot of reasons, if you own two or three companies, you want to make
Yeah.
sure they're really separate. They keep separate books.
That's
they do
another.
separate things.
It's a topic
Whole
for
other
another day
topic,
because
yeah.
even with real estate, I notice that a lot of towns, and I don't know if it's universal, a lot of towns, if you separate, people put properties in different names.
Mm-hmm.
They'll use a trust, they'll use their sister, their brother, their something. And it could be that they're in business with their sister, their brother, and this. So the brother owns this one, the brother owns that one, the brother owns this one. But you go before the town, and for their purposes, they're going to say, well, it's all under your control. So the new zoning laws have, the lots have melted in with each other, and you're out. You don't have 2, 3 separate lots anymore. We're telling you it's one big lot. And then
Interesting.
you have a big fight on your hands. And that's interesting.
Oh, have there been any cases like this or any other
Well, that's got
recent?
nothing to do with non-compete, though. So there I go, switching the subject.
But I learned something. So I don't do zoning law. So I did not know that.
Yeah, isn't that funny?
Interesting.
Yeah, it's really it's too bad. But the thing with the non-compete, there's your employee laws. It just depends. Years ago, we had somebody who played the piano on the side, and she wanted to get some gigs for weddings. Separate. She was a bookkeeper, had nothing to do with the entertainment or anything else. So we helped her. You know, we set her up with this agency, that agency, this agency, that agency, and she plate for ceremonies for which she got the fee. So when it came time to be audited, this is years ago, they're saying, oh, well, that's part of her 40, that you have to pay her overtime for that. So anyway, there was differences of opinions.
Yeah.
So the federal auditors went with that you didn't have to. They were two different jobs, absolutely separate.
Yep.
But the state says, well, it's the same person and it's from the same people. Anyway, the federal won out because it's just, you know, it's not fair. But there's nothing fair. So
Some things.
the thing is,
Some
you
things
just
drive
don't
me
help people sometimes. But that's interesting too.
Yeah, it's, you know, I think you mentioned, I think, Camille, have there been any cases? No, this is,
Still new.
Well, no.
you know, it can take months to years even for new laws to sort of get into the courts and get decided and get interpreted.
People won't even know about it unless they're sitting and saying, I got to do something. This is crazy. I can't get a job, or they're not letting me do this, and this one says I can do that, but I got to get a lawyer. Now, who pays the lawyer?
The employee.
The employee has to
Yeah.
pay the lawyer. What if they win? Then the judge can say,
I
the
don't,
employer.
I'd have to check. I don't think there's a fee shifting provision. I mean, typically in most
Fee-shifting.
cases, most times that you go to court, the American rule, as they say, is that each party pays their own lawyer. There are some specific laws, like the wage and hour laws, that put that burden on the employer. I don't think that that's in this new statute. But what I think may happen, speaking of people not knowing about it, is, you know, you're going to know when you leave a job if your employer is trying to enforce a non-compete, because they're going to write you a nasty letter or sue you or tell you you can't do what you want to do. The danger on the other side is that there are employers who are not paying attention, who hire a new employee after October 1st of 2018 and hand them their old non-compete that wasn't written to comply with the new laws. They may
Well,
not be able to enforce that.
Another question. You're saying the employees, you brought up a very good point, the employees may not know it. The employees are busy running their business. Who are their people that they have help? Should their lawyer tell them about it? Should their accountant tell them about it? Should their payroll service tell them about it? Who is supposed to keep up with this that they can blame?
Gosh,
afterwards?
you keep asking these
Seriously.
questions that are great, and there's entire other shows. It's a wonderful question. It's like the dilemma of the
keep
small
you
business
busy.
person.
Yeah.
It's the dilemma of the small business person. If you've got a huge company, you can sit down with your in-house legal counsel, your human resources director,
human
your chief
resources.
financial officer, and your chief cook and bottle washer, and say what's new.
Who's supposed to know this? Who's supposed to keep up with this? Like you say, you're human. If you have a human resource,
If you
or
have a human
operations
resource.
manager, you're who?
So for like wage and hour things, most people who use payroll services, the payroll services will keep up with changes in sick time law and minimum wage and, you know, all that stuff that you accrue paycheck to paycheck. This kind of thing, if you have a lawyer that you have a relationship with, you'd like to think they would let you know, but a lot of people really don't have enough need for legal services that they're in monthly or quarterly contact with an attorney.
Isn't that interesting?
And it's a huge problem. It's a huge problem that contributes to people who are trying to do the right thing finding themselves in a lot of legal trouble,
Yeah.
particularly with employment laws.
Interesting.
Interesting.
So
Okay,
what's our next topic?
We
Thank you.
both said the same
All
thing.
right.
I said, boy, that's pretty good. That wasn't rehearsed either.
There you
What's
go.
our next topic?
We've just known each other for so long
Yeah.
that we just know what the other's going to say.
Emily's used to us too.
There you go.
All these years now, huh?
I can't quite say the same thing as you guys at the same time, though. I think that's your superpower. So, other things that are new: paid parental leave or family leave in Massachusetts. It's rolling out over a period of years. So we've always had the federal law that says you get up to 12 weeks job protected leave to have a child, to adopt a child, to take care of an illness, to take
Men
care
and
of
women.
men and women.
Oh.
Well, men to yes, there's a little nuance there, but generally. That only applies if your business has 50 or more employees, and the employee taking the leave has to have worked for a certain amount of time,
Oh,
roughly a year. So that doesn't cover a lot of people. And it's unpaid leave.
Unpaid.
Oh.
Your employer
Unpaid.
can pay you if they want to, and they may choose to because it may be worth it to them to keep you in the fold and have you back when you're done, but they don't have to. So what's rolling out of Massachusetts is a state family leave law, which applies to a smaller size. I believe it's 23 or 26. But what's interesting is it looks like it's going to work a little bit like unemployment. Employees will be eligible to get some income, but it's not a check written by their employer. So employers of a certain size are going to have to start contributing to this fund. That's a state fund.
oh, the state pays you? I have to tell you, in California, because our new 11th grandchild is there, my daughter-in-law is on a paid, I'm pretty sure it's a paid, I'm not sure. It's either
Yeah.
paid or unpaid, but I think she got 3 months, and then
Okay.
she has to go back to work.
Yep. It's paid through this by the state, but not by tax dollars in the same way that you would think. So think about unemployment. If you, every time you do a payroll, you make a contribution to the unemployment fund.
Excuse me.
Bless you.
It goes into a big pot, and anybody who's laid off goes and applies for unemployment, and they get their benefits paid out of that. So I'm not writing a check for unemployment for my person that I laid off, but I'm paying into the system. So that's how this is going to work.
Oh, the same way.
That's how I sort of read it and understand it. It's not going to start, that whole system hasn't started yet. It's going to start sometime in 2019.
What does the employer do? The person is on leave. How do they get their work done? They have to hire somebody else, and then say the person wants to come back to work. You have to take them? I mean, you don't need them anymore. Somebody else, that can be a long time. Somebody else has been doing it. I can't
Yeah.
let them go too. I got along without you. That's like, say somebody says, I never take a day off because then they'll know I can be replaced.
That's not a good long-term strategy, I would say. But no, you're right. It's a challenge.
What
and
do
that's
they
what
do?
job protected leave means. You don't have to pay them, but when they come back,
You have
cleared
to
for
take
work.
them?
But remember, this is also, I think, why there are size limitations. 50 at the federal level and lower. So if you're a mom and pop shop with 3 employees, I think both sets of laws understand that that's a bigger deal for you to get by without one person for 12 weeks. If you're a much larger company, it's expected that you're able to kind of fill in for a little while. Does that make
And
sense?
the other part of the question, I think, is when they do come back, is the employer supposed to guarantee that their existing job will be available to them, or just that they will continue to be employed by the company?
It has to be comparable. I mean, if you truly need to move them from one department to another, and that is working for your business, as long as you're not giving them a cut in pay, benefits, you're returning them at the same essential status, but their actual tasks can be different.
I see.
Can we call that a you've got to be kidding? 'Cause
Sure.
then you've got to be kidding. But we got through. You had 3 things. We got through, say 1.5, almost 2. But I know what's going to happen is I'm going to get calls from people, and a lot of times I get the calls from the cable station saying people are wondering, where's the rest of it? They have to make a decision on something, and they're waiting for the rest of it on Emily Smith Lee. That happened when you did that thing on mortgage
right.
foreclosures. So anyway, here's our you've got to be kidding bag. But the reason,
YGTBK.
But-
You've
but-
got to be kidding.
yeah, but another thing is, I wanna say this quote. And this is a good quote. This is from a young lady by the name of Priscilla D. And she writes, she has these sayings every now and then, and I'm saying, God, that's remarkable. She's in her 20s. This is her latest one. No one is you, and that's your superpower. I read that this morning, feeling like before I felt that way, and I'm going, my God, that's wonderful. That's right. That's my superpower.
Exactly. It's true.
I used to say I didn't have to worry about identity theft because no one wanted to be me.
That's a good one. You got to be kidding.
Yeah.
Okay. All
No,
right.
but this Priscilla D, fascinating girl. By the way, this is the thing. These are new crayons. Besides giving out our police officers or our friends books, we now give out crayons.
So they can use the crayons to color in the book.
Yeah, or the walls. Who was it? It was, let me think of it. My Laura used to, she wrote on the walls with the crayons after the guy painted it. I remember the guy saying, I just painted that room. I go, well, what are you going to do? What are you going to do? I think she was 2 years old. What are you going to do? She's doing.
So, Emily,
Paint it again. I'll pay you over.
we have lots more to talk about.
Yeah.
And so we actually
Come
are going to
back.
have a next segment,
Yep.
part 2. This is part 1. Part 2 will follow, and we'll talk a little bit more about the topic we've just ended with, and then we'll talk about
Yeah.
our third topic, which is, remind me,
Some changes in the equal pay laws.
equal pay law.
Yeah,
Okay.
that's good too.
All right.
But for our viewers out there, you may not see the second part of this for a few weeks, but we're worth waiting for. That's what I hear.
Yeah.
Also, if anybody has a town that we haven't hit yet, the last one was Braintree, and we're working on Reading,
Great.
Reading, Massachusetts. So
Fantastic.
if you have a town.
And
we-
how many towns does that make now?
Well, the Braintree was the 15th, but we have requests for about 12 to 13 more.
Holy.
And it seems every time that we get down to 3 more towns, there's a whole new bunch of requests comes in. But
Whoever
it's
would have
really-
thought it, and it's
re-
just a
really
wonderful,
wonderful.
wonderful campaign.
Yeah. And
So, shall we wrap up this one?
Yeah, wrap
okay.
up.
So, to our viewers, we thank you very much for watching. Emily always has interesting topics because the world of employment changes all the time, and we need to keep up to date, whether you're an employer or an employee. So, we ask you if you have any questions, please let us know. We'll be happy to address your questions, or if there's something for Emily, we can forward them on to her. And right now, we're going to close this segment, which is part 1, and please stay tuned, whether it's right after this or whether it's sometime later. Stay tuned for part 2, which is more on employment law with Emily Smith Lee. Please stay in touch with us. We'd love to hear from you, because remember, this is your show, the law, your money, and you.
you.